So one of the things that's just started happening, the first cases being filed in August of last year, is this hearing over a limitation of benefits for totally disabled workers. The law changed as of June of 2011, and there's now a 500-week cap on total disability benefits for workers injured after that time, unless they go back to court after 425 weeks and prove that they are still disabled and entitled to benefits beyond the 500-week period. So the first of those cases have started being filed again since August of last year because of the way the statute was written, because the 500 weeks extended so far into the future. The law changed in 2011, but now these cases are finally going to start going to court, and we're going to get some decisions, and then those decisions are going to be appealed, and then they're going to go to the full commission, the full North Carolina Industrial Commission on a first appeal, and they're going to interpret what the plaintiff needs to prove in order to get those benefits extended beyond the 500 weeks. And then at least some of those cases are probably going to go on to the North Carolina Court of Appeals and probably even the North Carolina Supreme Court for a final interpretation on these laws and on this new law, relatively new law, and what is required of the plaintiff in order to get those benefits extended. Now, the catch with all this is the cases aren't all the same. So what one plaintiff may need to prove may be different than what another plaintiff needs to prove, but we're going to get there, and we're going to have a better idea as to what we need to prove in order to keep those benefits going for our client when we feel they are still disabled and can't go back to work. There are some good arguments that the law has not really changed in what we have to prove, that there are plenty of examples, plenty of cases out there that talk about what the plaintiff's burden is. There are defense attorneys, there are defense positions that say otherwise, that there is somehow a higher burden than what's always been in the past for the plaintiff in order to get these benefits extended. I disagree with that, but I don't get to make the final decision. That's what our appellate courts do, and that's what we will be dealing with over the next several years. So in the meantime, we do the best we can to provide as much evidence as we possibly can that would show that our client is entitled to those extended benefits, and then we proceed, and in the end, we're all going to find out exactly what the level of proof is, what the burden of proof, what the burden of production, what has to be shown to satisfy the plaintiff's burden to prove that they're still entitled to benefits after that 500 weeks. The other thing that's different is even if you win on that 500-week cap and get the benefits extended for life, you've still got to deal with, depending on your age, a credit for Social Security retirement at some point in time. So full retirement benefits, not disability benefits; those don't offset it. But if you're at full retirement age and your benefits are converted over to Social Security retirement and not Social Security disability, and you're after the 500 weeks, and you've won your case, your benefits are going to get reduced by the amount that you receive from the Social Security Administration. So that is another change. The law before that was if you're totally disabled for life, you get that same amount of money for life, no extra court trip and or appeal to keep the benefits going, and no credit for retirement benefits, but that has changed. So that's where we are. There are, I'm sure, plenty of unrepresented people out there who are in that situation who have either already gotten a copy of a hearing request from a defense attorney that they want to go to court over whether that person is disabled. What that means is they're looking to cut the benefits off at the 500-week cap, and that's going to keep happening over the course of the next months and years. That this is going to happen. There are going to be other circumstances where they don't file anything in underrepresented cases and they just let the clock run out. So if you're in a circumstance where you were injured after June 24th of 2011 and you are still getting total disability benefits, and you are approaching 425 weeks out from your date of injury, so basically about eight and a half years, then you need to go talk to a lawyer. You need to come in and sit down and talk about whether or not you should be entitled to get those extended benefits, and then what it's going to take to prove that case, because you are going to have to file something and go to court. If you have any questions about your case, if you feel like you may need help with your workers' comp claim, give us a call at Dodge Jones. I'm happy to sit down and talk with you and let you know what I can do to help.